This material is made available to you by or on behalf of the University of Melbourne under Section 113P of the Copyright Act 1968. It may be subject to copyright. For more information, visit the University Copyright website.
We might get underway if we can. Cut across your wonderful conversations. Can we commence tonight's proceedings by acknowledging that we meet on the land of the Wurundjeri people of the Kulin Nation and pay our respects to their elders past and present, and indeed to any Indigenous peoples who are joining with us this evening. Come on in. Nor starting later, I hope, whoever said that. Good evening, distinguished guests, ladies and gentlemen. My name is Pip Nicholson. I'm the Dean here at the Melbourne Law School, and it is a particular pleasure to welcome you all here tonight. I'd particularly like to acknowledge our guest speaker, Ms Patricia Viseur, Special Advisor for Gender at the Office of the Prosecutor of the International Criminal Court. I do want to make clear tonight, and I do so now, that Ms Viseur is speaking in her own personal capacity tonight, and by doing so is very delighted to be able to give her own take on a range of the issues that she'll be exploring with us this evening. I'd also like to acknowledge the Asia Pacific Centre for Military Law, who is co-hosting the event tonight, and indeed my thanks to Professor Hilary Charlesworth, who's co-director of studies in the Human Rights Law program at the University of Melbourne. Hilary has been instrumental in bringing Ms Patricia Viseur to us this evening. They've known each other for 25 years, but first meeting in person, in fact, only a couple of years ago. And we're really thankful to you, Hilary, for your agency in pulling together the visit and the very, very interesting lecture that we are bound to hear. A couple of housekeeping notes, if I may. This event will be photographed, and if you're uncomfortable about that, just indicate to the photographer that you don't want to be included in the snaps that are ultimately used. The event's proceedings are also being tape recorded, and they'll be available from the website in the not-too-distant future. And so the final request I have of you all is that this is the moment to turn off your mobile phone. I'll be checking mine in a minute, but in an ideal world we wouldn't be interrupted by a piece of technology in the form of a phone this evening. Now, can I take the opportunity to introduce our speaker and very briefly her topic tonight. Ms Viseur will be focusing on the future of the International Criminal Court and recent developments in its jurisprudence. Tasked with bringing to justice perpetrators of genocide, war crimes and crimes against humanity, the ICC has recently faced criticism regarding its jurisprudence and response to the occurrence of serious crimes, as well as accusations of political and regional bias. This evening we are in the hands of an expert who will outline the legal impact of recent controversial cases decided by the court, including those cases concerning former President and Commander-in-Chief of the Movement for the Liberation of the Congo, Jean-Pierre Bemba, former alleged Deputy Chief of Staff of the Patriotic Force for the Liberation of Congo, Bosco Ntaganda, and former President of the Republic of Sudan, Omar Hassan Ahmed Al-Bashir. I just want to make a few preliminary comments by way of introduction. Our speaker tonight is evidently an international criminal lawyer. She is the Special Advisor for Gender for the Office of the Prosecutor of the International Criminal Court. She's also a visiting fellow at Kellogg College at the University of Oxford, where she teaches international criminal law and human rights law, and also a practicing professor at the London School of Economics and a senior research fellow at the Human Rights Centre at the University of California in Berkeley. So as advises governments such as Colombia, Guatemala, Libya and Kenya, international institutions such as the UN and the OSCE, and civil society organisations on international criminal law and humanitarian law. Her expertise focuses on the strategic investigation and prosecution of sexual violence. As such, been intimately involved in the Special Legal Consultant to the UN Women, to the Gender and Women's Rights Division of the United Nations High Commissioner for Human Rights, and to the Secretary General Special Representative to Children in Armed Conflict. Sellers was the legal advisor for gender, acting head of the legal advisory section and prosecutor at the Yugoslav ICTY Tribunal from 1994 until 2007, and legal advisor for gender at the Rwanda Tribunal from 1995 until 1999. She developed the legal strategies and was a member of the trial teams of Akayasu, Nkurunziza and Kunarak. These landmark decisions remain the preeminent legal standards for the interpretation of sexual violence as war crimes against humanity, genocide, torture and enslavement. In 2012, she was a member of an expert panel to review the UN Office of Internal Oversight that has initial investigative jurisdiction over UN peacekeepers. She's the author of numerous articles, and I'm not going to list them all because there is a formidable list. She is also the recipient of the prestigious Prominent Women in International Law Award by the American Society of International Law. We are in the hands of someone who is preeminently qualified to comment on the topic that she has selected to talk to us about tonight, and I am delighted to welcome you.
Thank you very much. Thank you very much. I particularly enjoy that your name is Pip, and I want people to call me Patty. I think Pip and Patty make a formidable. I also extend my thanks to all the persons who have invited me, have supported me, new friends that I just met this afternoon, and long-term colleagues over the years. And I particularly thank the students who have come out tonight. I know it's not required, it's not mandatory. You will not receive a grade on this, and you might not receive any wisdom. But one day in the future, you might look back on tonight and understand the complexity of international criminal law. And what I would like to convey is not just its complexity, but that at this particular time point, it is bound between two things: aspirations and practicality. When the Rome Statute first came forward in 1998, when it was being negotiated, when it finally comes into force in the early aughts, around 2002, 2003, the aspirational part took precedence. Finally, after over 50 years, there was a multilateral institution that would look at international criminal law as applied to those member states of the Assembly State Parties who agreed to come under its jurisdiction. In many ways, this was possible because the Cold War had ended, because there was no longer that primordial discussion between the Soviet bloc and the United States or the free world. It opened up a space first where the ad hoc tribunals could be created for Yugoslavia and for Rwanda, and then for the Special Court for Sierra Leone. And in this glorious moment of we can apply international criminal law, it was no longer just the purview of humanitarian lawyers who were military advisors, or a couple of nerdy professors who couldn't get together at a conference of more than 5 or 6 on a good day, and would take turns sharing the seats on Common Article 3, or should we be looking at what is actually targeting or not. Here the world was going to explode. there were going to be people who were going to practice international humanitarian law, and a primordial institution, the International Criminal Court, would be their main focus. This aspiration included an aspiration on different forms of sexual violence, but it also included aspirations of an enlarged number of crimes that now would apply to armed conflict. So we have expanded jurisdiction, meaning the number of substantive crimes for international armed conflict and for non-international armed conflict. At the same time, this was to be a very practical institution. The states would be the first stop to try these crimes, meaning complementarity. The International Criminal Court only complements what the state has decided it is unable or unwilling, or is found that it is disingenuous to come forward to adjudicate. So the ICC jurisdiction was really a mechanism that usurped no power, that recognized the power of the states, and that somewhere underneath recognized that the international community needed not so much an institution to safeguard it, but an institution that it could turn to when states could not safeguard themselves. The practicality was also exercised with the United Nations. Here we have a new multilateral institution that has agreed to have a relationship with the United Nations, and in particular the United Nations Security Council. I call that relationship a little bit like kissing cousins. I don't know whether you have kissing cousins here in Australia, but within the African American context, your kissing cousin is someone who hangs around your family so much that you've forgotten whether you're related or not. They're just always at the barbecues. And while there might not be a blood relationship, there's such a familial relationship that you would dare never to disown this person. So the United Nations agreed that they would be a type of kissing cousins with the International Criminal Court in the sense that they would refer cases to the court, and in particular cases that came from geographical areas where these states were not member states of the Assembly State Parties. It's like, I've got your back if someone didn't sign up but have done horrible things. And they said, I only want one qualification, that I'm also able to stop your investigations and review them for up to a year for these cases that I refer. And that seemed like a pretty good relationship. It seemed very practical, and at the same time, it was aspirational. The United Nations was backing this International Criminal Court. But at times we have unmanageable aspirations. We have impractical practicalities. And today we find ourselves with the Rome legal regime being bound by these impracticalities, by these unmanageable aspirations. Beyond that, it's an institution that had to situate itself in a political landscape and at the same time change that landscape. Which landscape am I talking about? I'm talking about the post-World War multilateral institutional landscape, from which we have the United Nations, from which we have NATO, from which we have the different World Banks, the IMF, we have the European Union. Multilateralism became a means and a mechanism to resolve problems, or at least to confront problems, in the post-World War II society. It was seen as a great advance. And I would like to situate the International Criminal Court within that legacy of multilateralism. I'm going to come back to that point in a little bit, but what I would like to first turn to is, prior to addressing the different, let's say, complexities of the International Criminal Court's jurisdiction, such as where's your arrest of Al-Bashir, such as where are your convictions for sexual violence, such as why are you looking at Africa as a continent more so than other places. And I'd like to talk about a bit of the jurisprudence that has really gone under the radar screen, but which I think is absolutely stunning. The first case I'd like to talk about, and it's not a finalized judgment. As a matter of fact, it's an interlocutory appeal, and it has to do with same-side sexual violence. It takes place in the Ntaganda case. Ntaganda is a case, as Pip said, from the DRC, the Democratic Republic of Congo. And as a jurisdictional issue, to find out whether this case can even be brought before the International Criminal Court to challenge the prosecutor's charging document, defense counsel said, children, in particularly child soldiers, do not have the standing or status to allege that sexual violence has been committed against them if it has been committed from the same side of which they are a child soldier. As a matter of fact, the issue of jurisdiction is that within the framework of international law or international humanitarian law, we readily recognize that under international armed conflict, we have a perpetrator on one side, a victim on the other side, and that victim has to be a protected person under international humanitarian law. Could be a civilian, could be someone who's wounded on land, someone who's shipwrecked, or a prisoner of war. And the perpetrator must come from the other side of the armed conflict. And we also recognize that under non-international armed conflict, with the convoluted way that we basically say civil war, is that you have a perpetrator on one side, and the person who's a victim has to be a person who is no longer in combat, hors de combat, including a combatant who has laid down their arms. So they don't have to come from another state. They basically have the perpetrator and then the non-participant, the one who is no longer a participant in armed conflict. So child soldiers falls in those cracks. The child soldier might still be participating in the armed conflict. So if the perpetrator sexually abuses a child soldier on their own side, does the framework of international law address that issue? And if the framework of international law does not recognize that child soldier as a victim, then can a charge of sexual violence against that child soldier come under the jurisdiction of the International Criminal Court? That was the issue. The defense team litigated this at the pretrial stage. The pretrial chamber said the prosecution has jurisdiction to bring the case. Then they litigated at the trial stage. The trial chamber says, we recognize jurisdiction. Then they appealed the trial chamber's decision to the appellate chamber. And the appeals chamber said, send it back down to the trial chamber. We would like to look at a couple more issues related to the jurisdiction that you have over this case. The trial chamber again found it had jurisdiction. The defense again appealed it to the appellate interlocutory. So what I'm referring to now is the final interlocutory appeal, still at the trial stage, in terms of whether child soldiers can be sexually abused, in particularly rape and slavery, by members from their own side. What the appeals chamber found was that there was no status requirement under the Rome Statute. You didn't have to belong to one of the categories or be hors de combat or have been put down your arms. Their ruling was slightly, not ambiguous, but slightly, I would say, maladroit, a little uncomfortable. They basically said, we can find no rule that excludes the child soldier from protection. Therefore, we cannot say that the child soldier is not protected. That's very different than finding a rule that protects the child soldier. But this jurisprudence in and of itself has shifted the paradigm of war crimes. Now, one could ask, were they overreaching? Was this paternalistic, maternalistic, bad law? Or was this the purpose of humanitarian law, international criminal law? One could certainly say that there was a positive rule they probably failed to identify. We know that children have special protection in armed conflict. An additional Protocol 1, Article 77, that deals with international armed conflict, or additional Protocol 2, which deals with non-international armed conflict or civil wars, under its Article 4.3, states that special protection is mandatory for children. It then goes to say that that includes any form of indecent assault. And for those of you who don't know, indecent assault is code word for sexual violence. And it says that the parties, meaning the parties on any side, shall offer children special protection. And it says that if that child has been caught in hostilities or participated in hostilities, code word for if that child has become a child soldier, and that child is now held by the opposing force, captive or caught, under Additional Protocol 1, we can say prisoner of war, but under Additional Protocol 2, we can just say detained, that protection continues, which means that the detaining power cannot sexually assault the child because their protection continues even if they're child soldiers and even if captured. If one looks at that same series of provisions from the other way, when something continues, when one shall, it continues from a point, which means that it had to start at the point when the child soldier was with their own side. The protection started there and it continues even through detention and prisoner of war status. This continuing protection is actually a positive obligation that the appeals chamber hasn't recognized and that the prosecution will now offer again in its closing arguments, or has offered in its closing arguments. When one looks closely at Pictet's commentary of how one is to treat adult prisoners of war, it is noted that the detaining party in international armed conflict is supposed to separate female and male prisoners of war. Why? Not just because the detaining party's guards might sexually assault the prisoners, but that the detained prisoners might sexually assault each other. It's a positive obligation that you have to protect prisoners within your realm, but once again protects against same-side sexual violence. This type of jurisprudence that has come out of the International Criminal Court, and I can see by the stunned look on your faces, is under-examined, is too readily ignored, is a monumental piece of jurisprudence. I think in the future it will be normalized. It will be normalized along with the other paradigmic shift in war crimes that children have always represented. When you think about it, recruiting, conscription, or enlistment of child soldiers is illegal, and the perpetrator usually is the same side of the child soldier. So somewhere through recognizing the jurisprudence, but also the situation, situating children within armed conflict, the ICC, the chambers, but also the prosecutor, I think have perpetuated and strengthened, not breaking of a paradigm of war crime, but strengthening the protection, and particularly the protection of children who participate during war. The next bit of jurisprudence I'd like to turn to is one that is less obvious, but just as important. And it relates to the pretrial phase. There's been a recent judgment at the court where the pretrial chamber has said that the prosecutor cannot open up an investigation in Afghanistan. It's called the Afghanistan Decision. It has sent most of the international community into one form of shake or shiver. I think it was shake on the side that were rooting for Afghanistan and shiver on the side that are now terrified of when and where can we investigate. The basis is that the Office of the Prosecutor had a preliminary examination, which is not the same thing as an investigation. A preliminary examination is to find out whether there's a reasonable basis upon which to investigate into occurrences in Afghanistan. And the prosecutor came back and said that in the situation of Afghanistan, not the case, the situation, that there's a reasonable basis that crimes have been committed by Americans, by the Afghan security forces, and by the Taliban. And they went before the pretrial chamber to say, can we further our investigation? May we officially open up an investigation? And the pretrial chamber said no. It found that while there might have been serious crimes that could have come under the jurisdiction or potentially could be admissible, meaning that no state was willing to try them, that opening up an investigation would be difficult. As a matter of fact, they said, in the interest of justice, the investigation should not be opened. The preliminary examination to Afghanistan, in one sense, was aspirational. Finally, that paradigm of getting past victor's justice with a major power would have been breached. Investigation would have gone on with the United States, as well as Afghanistan, as well as the Taliban. I think if the prosecutor's office had only centered on acts by the Taliban, there would have been an outcry. And if they'd only centered on acts against the United States, there would have been another outcry. But they looked at the reasonable basis of crimes that could have been committed by any of these parties. And to open an investigation is then later on to find specific individual suspects for individual criminal responsibility. The impracticality is what the pretrial chamber brought up. It's going to be too hard for you to investigate. The governments and the factions will not cooperate with you. You will not be able to get into the territory. Believe it or not, this is a very old argument. This is an argument that every ad hoc tribunal had to face. It was difficult to get into Yugoslavia, horrendous to get into Rwanda during the genocide. Special Court for Sierra Leone that had low-range armed conflict going on even during some of its cases, was a very complex investigation site. But one could go back even further. In 1919, there was a commission of experts who were supposed to give their opinion on what types of crimes could we bring against Kaiser Wilhelm from World War I if we could try him. And the commission of experts rejected the application to try crimes against humanity, what we today call the crime of aggression. And their rationale was that it would be too difficult to investigate. There'd be too many witnesses. People might die. Why don't we leave that for history? But more importantly, why don't we leave it for historians? They might be able to do a better job than we are. And so one has to ask themselves now, with the pretrial chamber invoking the interest of justice, is this just another way to say this case potentially is politically too complex? Let's leave it to historians. Let's leave it to legal historians. Well, the final word in that is we don't know. Last week, the prosecutor appealed the decision. Victims' counsel appealed the decision. And cross-border victims, those who live in Pakistan and are affected because they've had relatives killed by either of the suspected parties, have appealed the decision. The prosecutor basically raised the issue of impractical practicalities is our everyday business. But the more important question that the prosecutor raised is that this was a constitutional moment for the Rome Statute. If we cannot undertake investigations because they might be too difficult or too hard, it is another way of basically deflating the very purpose of the Rome Statute. It strikes at the proprio motu proceedings that a prosecutor can do, and it also strikes at our functioning and our very legitimacy. That decision is outstanding. We do not know what the pretrial chamber or the appeal chamber will say about the pretrial chamber decision. And then the last issue I'd like to raise in terms of the complexity as it surrounds practicality and aspiration is the decision concerning head of state immunity. I think many of you know that Al-Bashir, who one can say right now is the former president of Sudan as of 3 weeks ago, was the outstanding fugitive from the International Criminal Court for the past 10 years. And he has been indicted. There's a charging document concerning his responsibility for acts of genocide and crimes against humanity in the Sudan. As many of you know, Al-Bashir never turned himself over to the court, but Sudan is not a member of the Assembly State Parties. It's not part of this multilateral network that upholds the International Criminal Court. So the question became much more so instead of in head of state immunity, is that when Al-Bashir travels to a country who is a member of the Assembly State Parties, does that state have the obligation under the Rome Statute, as a member of the Rome Statute, to arrest Al-Bashir and turn him over to the court? Well, Al-Bashir was in Jordan last year, and Jordan did not arrest him. Let me preface that by saying Al-Bashir has been in South Africa. Al-Bashir has been in many countries. And prior to this, the African Union has said, well, we don't want our members to be in conflict with their obligations under the African Union Charter, under the Rome Statute Charter, and we don't feel that our members of the African Union have the obligation to arrest another head of state in Africa. There's been intense debate, which has really shown the clash between aspirational and practical. Head of state immunity, once again, was discussed in the 1919 Commission of Experts after World War I. For 100 years, the question of head of state immunity has pushed its way to the forefront, breaking aspiration, invoking practicality. But we do know that Nuremberg and Tokyo certainly recognize that the head of state can be tried, although neither were tried at either of those tribunals. The in personam jurisdiction of both Nuremberg and Tokyo recognized that Hirohito or Hitler could have been tried. And we also know that at the Yugoslav tribunal, that heads of states have been tried. Kruna Jelic, Karadzic has recently been tried, and I've just forgot the name of the woman. Milosevic, yes, but the female. Plavsic, okay, thank you. So that's 4 heads of state that have been tried at the Yugoslav tribunal. Little is it known, the head of state of Rwanda, Kabanda, pleaded guilty. Didn't have to be tried. Pleaded guilty after arrest. The head of state for Special Court for Sierra Leone, Charles Taylor, has been tried. So there is no issue as to whether in personam jurisdiction covers heads of states. The issue became, does a member of the Rome regime, legal regime, a member of the Assembly State Parties, do they have the obligation to arrest a head of state who is not a member of the Assembly of State Parties? And the pretrial chamber found that they did. It was brought up to an interlocutory appeal, and the appeals chamber, the International Criminal Court, upheld the decision and said that head of state immunity is customary law and that Jordan should have followed through. Some of the dissension is that the appeals chamber didn't understand that the question wasn't head of state immunity. The question was the functioning of the Rome Statute. And should Jordan now be referred to the United Nations Security Council for failure to arrest someone who wasn't an Assembly of State Parties means? Aspirations and practicalities. That is the complexity of the International Criminal Court. Well, I cannot end my remarks without putting forward that this dilemma will never end. And as we focus on many things at the court, questions of arrest, these questions will come up because head of state could be Minister of Justice, could be Secretary of State. These questions will come up because if children are not allowed to be sexually violated by the same side party because they are child soldiers, but that same rule hold for adults who are sexually violated by the same side during war. In particular, when that violation is a jus cogens violation, such as slavery. And the same question will come up in determining what are the interests of justice. What are the interests of justice at the investigation stage? Do we look at the difficulty of the task? Or do we really look at our obligations, not too shy from the task? I'll close my remarks here and very willing to take any questions that you might have. Thank you.
Thanks for that great introduction to the court and the tension that you set up between aspiration and practicality. But now we've got a generous amount of time for questions and comments. I'd ask people perhaps to speak loudly, because we're not using microphones here, and to perhaps introduce themselves before they ask a question. Yes?
Yeah, I'm Hans Fair in the School of Social and Political Sciences. Does the Julian Assange case come under the jurisdiction of the International Criminal Court? Now, as you know, he's about to be extradited to the United States. But with WikiLeaks, he claims, and I think it's probably correctly, that various states or governments have committed crimes, including the United States. So, your thoughts on the Julian Assange case, because he is in Australia, but he's about to go, he's in Britain now, he's about to go to the United States. That was what happened there.
Well, the very quick answer is no. He's not committed one of the crimes that are recognized as invoking jurisdiction under the International Criminal Court. The fact that he said that countries have committed crimes, I don't know whether he's referring to war crimes, genocide, crimes against humanity, or all of them, is very different from the court having in persona jurisdiction over him. It seems like a non-stopper, but that's part of the aspiration. I mean, persons around the world almost assume that the court must cover this. And there are many things the court doesn't cover. But remember, it comes through the Assembly of State Parties being a member and then the jurisdiction, the subject matter jurisdiction of the court. And Julian Assange is an individual, no. And he can't invoke that as an individual either, unless he comes forward with evidence to present to the prosecutor and ask the prosecutor to open up an investigation. Do you think they'd say it would be in the interest of justice if he did? No, I was just kidding. Do you think that the court would say it's in the interest of justice to open up such an investigation?
Well, it seems to me that the court should look at this kind of thing. I'm not a lawyer. I'm an anthropologist. But a transplanted American is in Australia about 15 years. But certainly governments, including the United States and Australia and Belgium, they commit crimes.
Yeah, I think what you're vocalizing, if I can translate, although we're both speaking English, is that there should be a sense of justice. What you're feeling is, where is my forum for a sense of justice on this issue?
I think Maggie.
What do you think about the...
You might just speak quite loudly, just so everybody can hear your question.
So, on your practicality point and the Afghanistan decision, is there something to be said for the fact that the ad hoc tribunals, Rwanda, Yugoslavia, and the Special Court had primacy or supremacy over domestic law, whereas the the ICC statute gives primacy to states, and therefore in asserting jurisdiction, and therefore that causes an insurmountable barrier to effective investigation?
I think in retrospect, if one were to examine their own statute now, we can realize in some manner it's very state-centric. And that was the idea, that the states really are supposed to exercise their jurisdiction first, and then the International Criminal Court comes in. But in the situation with the Afghanistan investigation, we're not even at that point yet. We're at the point where an organ within the court is telling another organ within the court, do not go further in this investigation. So the state is not even saying whether it's Afghanistan or the United States or the Taliban, oh, I'm willing and able to do it, or this is disingenuous. We're not even at that posture yet.
Can I just, if I could, Patty, just ask, there has been, excuse me, an outpouring of disappointment in the court since the Afghanistan decision. So all the blogs and so on have been full of grief about it, sort of saying, with all the promise, I think, that you're referring to, the sort of sense of hope in 1998 when everybody thought this was going to do something wonderful. Now there's this equal outpouring of disappointment. I'm interested in a couple of things. What's your take on that? Should we say, yes, it's all over, the disappointment's going to set in? And I'm also interested if, and I don't know if you could comment on this, what would be the sense within the court itself about all that public criticism? Does that, the fact that there's intense criticism about the utility of the court, does that have an impact within the court itself?
Yes. I mean, I think members of the court and members of the Office of the Prosecutor, the Bemba decision was devastating. The Bagbo decision also. There's a feeling of, I don't know if this is an appropriate thing, of kind of like, you know, you're in a line dance in a New Orleans festival and someone comes up in the back and hits you with a bat. You know, it just throws your whole rhythm off. You're just like, where did that come from? How did that come? You know, and as you're rubbing the back of your head and seeing there's blood on it, how do we get this back together? So there's that shock impact, you know, while you were in motion. I think the judiciary is also feeling that, because I think there's been criticism of the judgments and of the decisions and of everything from not just their conclusions, but how they've been written. So they're feeling that. And I think the fact that many of the politics of assembly party states in terms of wanting to withdraw from the court, such as Burundi, whereas before also South Africa threatened and Kenya threatened, this kind of pulling apart from within, in addition to being bombarded, I think we all know John Bolton's position on the court, being bombarded from states or countries that have signed and then unsigned, not even ratified, but Russia and the United States signed the Rome Statute and then unsigned it, you know, of course. So this feeling of this is a critical moment, you know, and one could say, you know, as part of the international legal community, have we just reached, you know, our end? Was this International Criminal Court not such a good idea? Were our aspirations just unrealistic? Were we in fantasy land in the 1990s when it seemed like the Cold War is over and courts and tribunals are just going to be tried and multiplied? And I think myself and many other members of this broader community, in answering that question, I don't know if we're at the point when we can have the answer for that. But I don't think we can just do a let's look and see. And I was reminded today, while doing some research, is that this might have been how it felt, you know, after Nuremberg and Tokyo, that there was this big, brave future that was going to happen. And right after that, all of a sudden, we get 4 Geneva Conventions. You know, there was a Geneva Convention in 1929 for POWs. It was a little, I don't know, Ozzy's here, excuse me, that's a little tiny little convention, okay? And then right after World War II, we get 4. There's this rush to write up new law. And then after the Geneva Convention, still in the late 1940s, we get the Genocide Convention. I mean, like, we're just trotting, boom, 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 boom. You know, and so there was this glorious period. And then we get the Nuremberg Principles too. And then between 1950 and 1994, almost nothing except for some additional protocols coming up in 1977. So I don't know whether we're ready to go into another desert, you know, of international criminal law enforcement or development, and then the desert lasts for 20, 30, or 40 years, or whether this is just, you know, a gray period, and that within 2 or 3 years, you know, there are cases that are scheduled to come out of the International Criminal Court now. Ntaganda will come out. Ongwen will come out. There's going to be a new preliminary hearing on July the 8th for the cases, one of the cases in Mali. And this inability of the International Criminal Court to be so outstanding has really spurred a lot of universal jurisdiction in certain, and particularly in certain European fora, in Switzerland and Germany and France, but also states that have been pursuing these crimes, such as particularly Guatemala, Bosnia. Argentina is underrated in its international criminal law jurisprudence. It probably has more crimes against humanity cases that have come out of the dirty war era than any other country, but translation is a huge issue.
Hi, thank you for your presentation. Ntaganda from Monash University. You said that the ICC hasn't yet had a conviction for sexual violence. So what do you think has to happen for there to be a conviction on a sexual violence charge?
I think three things have to happen. First of all, you have to have well-funded investigations, because it's not that investigating sexual violence is more difficult. It's that when investigators have the pressure of funding, it seems that it's easier to do forensic investigation, things that are physical. And I think that most of the sexual assault investigation, other than physical places where it might have taken part or looking at diplomats' notes, has to do with person-to-person contact. It has to do with an investigator being able to get the trust of that person, whether it's the father of someone who's deceased who was sexually violated or the person who was sexually violated. And in my experience, sexual violence interviews usually take their minimum 2 to 3 days. That's if you're, in quotes, lucky. And I would say that's for females. I think for males, a week to a week and a half is normal. They will tell you about the whole war, then go back and through the detention camp. And finally, right before you think this interview is going to be over, they'll say, look, you want to have a coffee? And then you know that you've reached a point and you need 2 more days. So I think that we have to put resources up front. The Assembly of State Parties has had a flat budget line for investigations now for over 10 years. And then we have to put resources during the trial and then after the trial in terms of reparation and compensation for victims of it. And I think that's one of the practicalities that we have to get to. I think if today we were to put a price on Nuremberg and Tokyo, it's priceless. How much would you pay for it to happen or not to have happened? But yet we don't want to look at current investigations, national levels and international levels, as being too expensive.
Thanks, Patricia. Melbourne Law School. I was wondering, really, sparked by your initial remarks about multilateralism, whether the problems, at least some of the problems the court is facing, have to do with a broader breakdown in multilateralism. The European Union just being one example, but is it reflecting more generally a reconfiguration of relations between states that is much less committed to cooperation and some kind of solidarity? So that's one thought. And the other one, I just wanted on the sexual violence. I wondered if sexual violence is still a contentious part of the interests of investigating sexual violence, is still contentious as part of, as a component of the interests of justice?
Mm-hmm. To your first question, I completely agree. It's one of my theses that this was one of the last multilateral institutions in the post-World War II phase, and we're facing the same issues. I mean, the EU is being pulled apart from within and from outside. NATO is being attacked, the non-recognition of Article 5, not to come to the help of one or the help of any. One could even look at the Inter-American Court, which has been threatened by pullouts by states and a retreat in this very belief that democracy and human rights have to sit together. I mean, human rights is being questioned, and on top of that, the different subcategories, if one could say, of human rights, women's rights, this notion of gender ideology as being a form of revisionism is being attacked within each of those multilateral institutions also. So I think that what the ICC in some ways is facing is just the political wave that's attacking the post-World War II structure. In terms of the sexual violence, I think that there's always a point where both investigators, prosecutors, victims counsel, judges, defense counsel, and registrar can improve what I call their gender competence. And whereas once the conversation centered more on sexual violence, now it centers on gender and seeing how do the different roles of gender inform, create systems during armed conflicts or genocide or crimes against humanity. And this is a much more sophisticated approach, but again, it's still, I would say, part of in an initial stage. I mean, this will take another 30 or 40 years before it becomes very much a common means of just looking at criminal conduct, whether in a nation state or whether during an international armed conflict.
I have two questions. Firstly, what are some possible outcomes for the ICC, state parties ignoring arrest warrants for head of states? And the second one is the ICC's attempt to move beyond Africa, and if this isn't got any prosecuting African perpetrators.
Right. Well, I think the ICC's reaction to a state party not arresting a head of state, such as in the Bashir case, is that the trial chamber really wanted to refer Jordan to the Security Council, and I imagine that would involve some form of sanctions. The interlocutory appeals decision said they were not going to refer Jordan to the Security Council because in many ways that relationship, as I said before, the kissing cousins, it's kind of like we refer people to you. We haven't quite worked out the practicalities. If we don't fulfill, if your states don't fulfill their obligations under this referral, what do we do? And I think that's what this interlocutory appeal could have set out much clearer. But it will become an issue in the future. I mean, there's no way that this issue will disappear. I mean, it could be resolved today by Sudan turning over al-Bashir. But Sudan probably does not want to turn over al-Bashir because if I were al-Bashir, I would say, well, I'll open up my diary and I hope that anyone who's turning me over is not in it. Right? So I think that's one of the issues. In terms of the ICC targeting African countries, I think that's incorrect, and for the following reasons. I think that African countries, and particularly Uganda and Democratic Republic of Congo, first handed over persons to the ICC. As a matter of fact, it jump-started the ICC. And they were persons or within the liberation, Army of Kony and Katanga that they really didn't want to have on their territory. So this was kind of a favor, and they would be seen as doing the rule of law. I think the situation in Mali when Timbuktu was occupied and the cultural monuments were destroyed, and now there's another ongoing case, I think if the ICC had ignored that, it would have been accused of ignoring the cultural value of Africa. And I think when the political violence broke out in Kenya and Cote d'Ivoire, I think it's so easy to say, well, that happens during elections, let's not look at it. I think it was a much braver step to say crimes against humanity can occur during a non-armed conflict time period and can be related to political elections. The prosecutor, the point she brings up more often is, why do you always want me to ignore the African victims? And I think that's another way of posing the same question. But in addition to that, there were ongoing examinations of Colombia at the time, Israel, the examination in Georgia is going on, and Afghanistan. So it's not focused only on Africa. And I don't think the United States thinks it's focused only on Africa the way Bolton is talking. I don't think he'd be pontificating as much if it were only Africa.
Thanks, Hilary, and thank you, Patricia. Carrie McDougall from Melbourne Law School. In the last week, the ICC ASP Bureau has been meeting predominantly to consider how to reform the process of nominating and electing judges because they're unhappy with the decisions. And not so much the Jordan appeal decision, but the Bemba acquittal and the refusal to authorise the investigation in Afghanistan.
Right.
So I'm wondering how that fits with the the picture you've painted of utopian idealism conflicting actually states that are saying, well, we don't like this failure to meet the aspirational ideals set out in the Rome Statute.
I think that the Bureau is recognizing that you have to have judges who really can step up and work with these very, very complicated cases at several stages. Today I've centered basically on a lot of interlocutory appeals. It's not just about writing the trial judgment after you've had 18 months to hear all the evidence. It's about looking at decisions that have to be made at the investigation phase, at the confirmation of charges phases, at the trial phases, at the interlocutory appeals during the trial phase, at the appellate phase. Okay? So it's wonderful if someone has memorized, the tome on Common Article 3, and that's the only issue in the case at the trial phase, and you're going to be the best judge around. But judging at international courts and tribunals, as at domestic courts, I think when they incorporate international crimes, is becoming more complex from the procedural point of view and also from the substantive point of view. And so I think the Bureau is trying to respond and maybe to get out ahead at the same time. And, there have been proposals by certain persons, I think Kayambos, to set up a judiciary academy. There have been proposals to have ongoing training of judges. There have been proposals to have judges, instead of either having criminal law experience or criminal experience in a national court, to have other criteria.
Speak up just a tiny bit, because this is the back row. Yeah.
I think one of the things that defines international law and international criminal law in the last decade or so was the conflict in Syria, or is the conflict in Syria. And I was interested to hear perhaps your perspective, to the extent that you're allowed to comment on it, on what the International Criminal Court could do in this context, given that Syria is not a state party.
Okay, and purely in my individual capacity on this issue, because Syria isn't a state party, and there's a very complicated geographical issue that arises. And when you had Daesh and ISIL, some of their territory bordered on Syria, bordered on Iraq. They brought in, dare I say, they recruited persons who came from Assembly State Party states. And so the issue of jurisdiction is very complicated. It depends on who might be the particular perpetrator or suspect, or what might be the underlying facts. So one can never assume that in the future that the ICC wouldn't have jurisdiction over some element of what happened. But I think your question is really going to a much broader issue, that how has the international community in the past 9 years, in quotes, allowed Syria to happen, or stood by as Syria was happening. And it rejoins, it goes back a bit to the earlier comment, then what good is your International Criminal Court if we have Syria?
Yes, just the last question.
Thank you so much for your presentation, Harry. My name is Jane. My question is just about the Afghanistan case. It's such a groundbreaking case, and I was just wondering if you had any reflections on what it's like to be part of that.
Well, it's been almost 20 years since we did the case.
You just might, just for those who don't know the
Right.
case, perhaps just want to sketch a
Right.
little bit.
The Akiyesu case was the first case out of the Rwanda, International Criminal Tribunal for Rwanda. And it was a case against a mayor in a small community called Taba. And the case was the first case to bring forward not only the Genocide Convention after it had lied dormant for 60 years, but it's a case that included sexual violence as a constituent act of genocide, so that the Rwandan genocide was basically composed of killings and rapings. Right? And the Akiyesu case was a case that during the prosecutor's case it had to be reopened because sexual violence wasn't initially included in the charging document. So getting back to what it takes to investigate and how the witnesses come forward. My feelings 25 years later, on the one hand, you know, I'm very proud and happy that the case is still standing on strong legs. And as a matter of fact, this is a commercial. There's a movie that was made about the case that included those of us who were in the trial team, members of civil society, but most important, the women who came forward to testify. And that movie's now available on Amazon.com or something, so down. And it's called The Uncondemned. Like, you condemn some people are uncondemned. So I was able to see the women last year when I was in New York. Where I'm disappointed, not so much in the case, is that 20 years later, it's still among the leading cases, and that there should be more leading cases by now, and not just in Rwanda, but in the other places where genocide has taken place. So that's a bit of my mixed feeling.
Let me just give you would have the last question.
I just wondered what you thought of Mr. Khashoggi that ended up in the inner city, one person, Ntaganda, and many persons.
I guess I should just say Saudi Arabia is not a member of the Assembly State Parties, right? Those are the things that one would really ask. You know, how do you? We're going to find out. How do you finally reach that in the Assange? I mean, the International Criminal Court isn't set up for that, but certainly there are crimes that have an international impact that are still going on, a political impact.
Well, look. Oh, is it very? You know, it's very short. Just a very short. Yeah.
This is more a philosophical question about the court itself, right? The people that are there, the judges, the people there, the lawyers, all the people that are basically there, how resilient are they? Because there's been some talk in the last 5 to 10 years, a lot of the judges were basically just burnt out completely and most of them there. When you see the court, can you see it ongoing with the people that are there and being that tenacity, that resilience that has to occur in that situation for results to occur from that?
Right. Well, the judges, you know, they have 9-year stays, so they switch out every 9 years. I think there are people in the other offices who've been there longer than 9 years, okay? And for them switching in and out, I'm sure it's like many of you. For most people, it's their dream job. You know, they're not going to, in quotes, give it up. But I think this question of self-care, of resilience, of taking a break and being able to still see a future is very, very important. I know that many of my colleagues do not admit to their own secondary trauma. I know I have it, and I know that I have it even after years of stepping away from the court. And I know many of my colleagues have it. I see it in them. They don't recognize it as that. They'll say that, you know, I just fight harder. If I'm argumentative, it's because I see, you know, the precision of the elocution that the judge. Yeah, you're a little traumatized. You should back off. It has to happen. I mean, if it doesn't happen, it means you're not human. Okay? I mean, it's a reaction to a human being seeing something that shouldn't be normalized. So yes, I think it's an issue.
Well, on that sobering note, thank you for your question. I'd like to thank you on all of our behalf. This wonderful. I mean, I think we feel very privileged here to have heard immediately from somebody who's been so associated with the development of international criminal law over the past quarter of a century at least, and it's wonderful to have the benefit of your wisdom. Some of us also had the good fortune of sitting down with Patty this afternoon in a discussion which was also wonderful. So thank you very much on behalf of Melbourne Law School for enriching us and bringing these very interesting perspectives. And I think it's very useful for those of us watching the court. I take the messages. Be worried, but don't give up yet. Yes. So if that's
good
the case,
answer.
Thank you very much.
That's what I meant to say. Thank you. Thank you very much.